we are very pleased to have Emma Himsworth, Ian Forrester, and Richard Arnold, Lord Justice Arnold. So I'm sure we'll have a lively debate with questions with Robin chairing the panel. I just wanted to say on behalf of Marks, this joint organisation, on behalf of Marks, welcome as well. I do this every year, but if you wish to have the support of Marks in any of your cases, as an intervener, we are always welcome to have them. So I'm no longer actually on the amicus committee, so I no longer draft these pleadings, but I have other team members who would do that, and we'd welcome that. So please just keep thinking of us if you want that support. And then Ian can probably tell you whether actually the CGU judges will listen to our pleadings, but still we will make them if we think that's the right thing to do on behalf of brand owners generally. So I will now hand over to Robin. There will be hopefully an opportunity for questions from people on the floor as well. We've had a few from the audience, which is new. Some years we've had none, but this year we've had a bundle, which is great. So we'll try and get some of those questions in, but you're still welcome to ask from the floor at the appropriate time that Robin invites you to do so. And then afterwards we are having drinks back at the in the main hall, just outside here. So that's great. Thanks, I'll hand over.
Well, here's our panel. It was going to be 4. We were hoping to have a judge from Scotland, but something went wrong. But on the other hand, we have got a judge from Scotland. So Ian Forrester will have to double up as a judge from Scotland, about which he knows very little about judging in Scotland, actually, because he's in fact unemployed now. And that may or may enable him to be a bit franker than he otherwise would have been, but I suspect he'll be quite circumspect about anything that might matter. He has quite a lot of interesting things to say, though. He told us lots of fascinating stuff at tea. And then we have Emma, an appointed person, and a very well-known one and a very good one. And then we have another appointed person to the Court of Appeal in the shape of Richard Arnold. So we've got a bunch of questions. Please join in. We're now small enough that we can pretty well do that. But if you join in, you ask a question, you don't make a speech. I beat up people who make speeches. And away we go. And the first question is, where do you think UK trademark law is going to go as compared with EU trademark law in the future? We're going to stay parallel with them, copying everything that comes out of the Court of Justice, or are we going to diverge? And if we are, in what areas might we diverge? And I think the first person I'm going to ask is Ian, because he's done more trademark cases than I have, or Richard. He told us he'd done 35. So he obviously knows more about trademarks than we do. Ian?
I said over the secret tea that I had a certain sympathy for Sir Alec Douglas Hume, who, when he was Prime Minister, I think when he was Prime Minister, maybe afterwards, but I think when, he said that he was always uneasy in going to the Treasury next door to talk about big numbers, and he could only do it with a clear conscience and efficiently if he brought with him a box of matches so that he could move the matches around and follow the millions and billions that were being discussed. I find myself sometimes in Luxembourg in the same condition of nervous uncertainty when trademark cases come along. So while it's true that I've done, I think, maybe something in the 30s, it is not true that I am expert in the field of trademarks. It is, however, true that the court has to decide appeals from the Trademark Office in Alicante. Now, the question that Robin put is of great simplicity and enormous political complexity. And I give a response, which is not really an answer, by noting that for 47 years, in umpteen fields of legal activity, from child abduction to seatbelt anchorage points, to what's a safe and efficacious medicine, and trademarks, the UK has pooled its sovereignty to legislate collectively for common problems that affect our daily lives. Now, the effect of that cooperation over the years has been the creation of a common market that offers to citizens things which are clean, healthy, efficient, and offers to, there's lots of seats at the front. Lots of seats at the front. It looks like the Church of Scotland where everyone sits well back to keep warm. Okay. There are there's many things that could be said in favour of common legislation to regulate our daily lives. And that has helped to create a market of 500 million people where little by little, step by step, not perfectly and not consistently, people have been able to live better. Now that's the spiel for don't do Brexit. Now, the choice remains, having done Brexit, do we regard divergence as an affirmative political virtue for which the British people voted, or do we regard divergence as something to be avoided for practical, economic, and social reasons? And the question which was put as to trademarks is an important one, and my answer is that no one can know until the government gives guidance, or in the absence of guidance from the government, the judges make very delicate decisions. And these decisions will arise in questions in fields other than that of trademarks. So when the question is whether the architect satisfies the criteria to be admitted to the profession of architect in England, has the course studied in Toledo been sufficient to satisfy the English requirements and the European requirements for tum. Now, the Court of Justice, the English courts, may regard consistency between how architects are qualified in Spain and how architects are qualified in England, may regard that as something important. Or they may regard it as something unimportant, or they may regard it as something affirmatively to be pursued. When I had a battle with the New York Bar over whether I could be admitted to bar membership, one of the reasons that I was rejected by the bar was that there were lots of foreign lawyers who were looking for a job, and there were unemployed New York lawyers. And admitting someone like me would make life more difficult for native New York lawyers. That was a legitimate point of view, which was reversed on appeal, I'm happy to say. But it's a very good example of the kind of question which it'll be necessary for the courts, and I fear the government is going to be reluctant to give guidance and instruction. That's a long answer to say, I don't know.
Richard, what would you say?
So, in answering this question, I think one has to start by explaining the basics. And in my experience, even now, many people don't understand. So my apologies to those of you in the room who know what I'm about to say very well, but I'm sure there will be some who don't. So we start with the EU Withdrawal Act 2018. The basic principle which underlies that act is very simply stated. It is continuity of the law. So the basic proposition that you find articulated in the provisions of the act is that the law should be the same after exit from the EU as it is before exit from the EU. Now, you may think that's paradoxical, given the whole point of Brexit is to be free of EU law, but the point is that the philosophy underlying the Act is that what Brexit enables the UK to do is to be free to change in the future, not that it changes our law ipso facto, other than being free of course, of EU supremacy. Now, where that leads to is that the way in which that is achieved is through the concept of what is called retained EU law. And to simplify very considerably, what that means is that all existing EU law, as at the date of Brexit, becomes incorporated into UK domestic law. So in that way, nothing changes. Now, you then have to overlay that with the effects of the 2020 Act, and I'll explain that in a moment. But just to finish up with the 2018 Act, what that approach does is to mean that legislatively nothing changes. So all EU legislation that has been implemented down to date of exit stays, so directives that have been implemented stays, regulations get effectively cloned in a virtual way and remain part of our law. And there is freedom for the UK Parliament or the devolved national parliaments as appropriate, depending on what type of field one's talking about, to legislate differently in the future. As regards case law, the existing decisions of the Court of Justice, according to the 2018 Act, down to the date of exit, are binding on all UK courts below the Supreme Court. The Supreme Court is free to depart from precedents of the Court of Justice, but only to the same extent that it is free to depart from its own precedents. So that's the basic structure you have in the 2018 Act. The 2020 Act changes that in two main respects that are relevant for our purposes. First of all, it moves the relevant date from the date of exit from the EU to the date or at the end of the transitional period. So instead of it being 31st of January, it's 31st December. And that's why, as we speak today, the law has not changed, despite the fact that we are no longer in the EU. The other change that's relevant is that there's a very curious provision in the 2020 Act which gives the government power by secondary legislation to allow courts below the Supreme Court to depart from Court of Justice precedents. So, where this takes us to going forward is that, legislatively speaking, there will be no relevant changes unless and until a UK or national parliament passes appropriate legislation. And we will have inherited a great deal of case law from the Court of Justice, and indeed the General Court, that will be binding below the Supreme Court, except perhaps if the government activates the power under the 2020 Act. So you are then faced with a very complicated scenario. So if questions come up in trademark cases, we will still have the 1994 Act as it presently stands. That will not change. We will still have the directive effectively forming part of our law. We will still have the regulation effectively forming part of our law, although, of course, as regards EU trademarks, there will be a difference in that they will be cloned and put onto the UK register. So the proprietors will have UK rights as well as their EU TMs. Now, in terms of where that takes us in terms of future development, it seems to me it's very, very much of an open question. There are two ways in which law can develop, either through legislation or through case law. If you're looking for legislative development, obviously that depends upon the will of Parliament, and in particular on parliamentary time being available. Now, as regards that, as many of you will know, I've been calling for a new Copyright Act for a number of years, and so far the response from government has been stony silence. Ask yourselves, what is the prospect of any legislative amendment to the Trademarks Act anytime soon? When is UK Parliament going to have time and the energy and the will to do that? I can't see that happening anytime soon at all. So the legislation in the short to medium term will remain the same. Possibly in the long term it may change, but that's very much a matter for speculation. So, no legislative change, and therefore no divergence on the legislative front. What about case law? Well, as I've explained to you, there's a theoretical possibility of divergence in the case law because the future decisions of the Court of Justice will, of course, not be binding. They will be persuasive insofar as they're interpreting the same legislation. There is also the possibility, either at the Supreme Court level or possibly at the lower level, of departing from existing precedents. But let's try testing that one, shall we? Let's take, by way of example, two decisions of the Court of Justice that it might be suggested that UK courts might be interested in departing from, given the freedom to do so. And I'll take them in reverse chronological order. So the first one I'm going to mention is the case of Mitsubishi, decided in 2018. This is the case about the forklift trucks, in which the Court of Justice, in its wisdom, decided that not using a trademark was using a trademark. Now, that is a decision which no commentator I have read has been prepared to defend. I've read quite a lot of commentary on that decision from quite a wide variety of sources, and I have not read one item that supports that decision. All the scholarly commentary says it is mad, and most of the practitioner commentary is not much less polite.
Even very, very pro-trademark owner commentators, such as Charles Heaton.
Yeah. Now, that is a decision which is in no way compelled by the legislation, and indeed it might be said to be a perverse reading of the legislation. So that is a decision where, if the matter came up before a UK court, you could see a rational basis for a UK court taking a different view once free to do so. But let me take another favourite bête noire, not least of our chairman, which is the case of L'Oréal and Bellure. So, again, this is a decision that has been much criticised down the years. However, the problem with that one is that whatever you think about what the Court of Justice said about trademark functions in that case, the actual outcome was dictated by Article 4G of the Misleading and Comparative Advertising Directive. And since then, of course, the directive and the regulation have been amended expressly to incorporate cross-reference to the Misleading and Comparative Advertising Directive. And the Misleading and Comparative Advertising Directive will be incorporated into our domestic law just as much as the Trademark Directive and the Trademark Regulation. So even if you went to the Supreme Court to say L'Oréal and Bellure is wrong and should be reversed, it seems to me the likely answer from the Supreme Court is going to be to say, well, how can we, when this is dictated by the legislation and the legislation has not been changed? So, yes, there will be freedom for divergence in some respects, but unless and until the legislation is changed, the freedom to change will be only in certain areas. And then you are faced with the question, which, as Ian very rightly points out, is a much more general question, which is the extent to which UK courts should avail themselves of that freedom, and that is going to be a question which is going to be exercising the Supreme Court for years to come.
Emma, do you want to add anything?
I was just going to make two very short points. First of all, I agree entirely with what Richard has just said, but there's the added layer in my view, which is that the UK government doesn't have a total free rein to make the changes to the trademark legislation that it might want to, because of course we are signed up to various international treaties which we are still members of. And so another reason for not wanting to change it is that we know the legislation as currently drafted is compliant with all our international obligations. And therefore, once you start fiddling with the legislation as it's currently drafted, you run a risk of running up against international obligations that we're still bound by, under, for example, the Paris Convention. So it's not completely correct to say there's an entirely free rein to amend the legislation in any event. The second point I was going to say was actually following on a bit from what Richard was saying about trying to get the Copyright Act changed, which I entirely sympathise with. But in relation to trademarks, and certainly on the various committees that I've sat on in relation to Brexit and going forward, there is actually quite a huge consensus amongst the IP fraternity that continuity and certainty is really important at the moment. And so I don't think there's going to be much lobbying for changes to the trademark legislation in the short to medium term. And I would have thought that the government will not find the time in those circumstances in particular to make changes. There is only one area where I think there could be a change, and it's up for debate, but it's essentially a political decision, and that's in relation to international exhaustion or national exhaustion. And there are a lot of arguments that are open on that point, but I think it's going to come down to politics rather than any legal arguments one way or the other. So those are the short points I was going to add.
Right, well, let me try another one. Yeah. You can no longer make references.
We can at the moment,
Well, you won't.
after 31st December.
You won't, yeah, but you won't get. Are you glad about that or sorry? You, Richard.
Well, for those of you who don't know, I spent 15 years sitting in the High Court, first as a deputy High Court judge and then as a full-time High Court judge. And in the course of that 15 years, I made 15 references to the Court of Justice. It was an average of 1 a year. I must say, having had that lengthy experience, I grew to respect the system. It's not a perfect system in any way. And as many of you will know from having read my judgments, I wasn't always best pleased with the answers that I was given by the Court of Justice. However, as a system, it worked pretty well. Because what it enabled national courts to do was to get definitive answers as to questions of European law. If you're going to have EU law being supreme, you have to have a supreme arbiter. So you have to have a top European court. And the great advantage with the system of references is it provided a very efficient way, if it was used correctly, in which to achieve common EU answers to questions of law. Moreover, in my experience, the Court of Justice is quite serious in its often proclaimed view that the essence of the system is what it calls dialogue with the national courts through the system of references. And you will see this through the court case law of the Court of Justice. I mean, I think jurisprudentially, the case law of the Court of Justice is fascinating because it's a hybrid between the common law and the civil law. What you will find in the jurisprudence of the Court of Justice, at least post the time of Lord Mackenzie Stewart, who started this, is you will find references to precedent. So you will find repeatedly in judgments of the Court of Justice statements saying, it is settled law that, see judgment so-and-so. So to that extent, they do have a system of precedent. But it's not strict stare decisis because they don't regard any particular decision as immutable. On the contrary, they take the view that their jurisprudence is evolutionary in nature, and the way in which it evolves is through dialogue through the national courts, through the system of references. And in any one area, you will see the case law evolving over time as new references throw up new problems to which new answers are required. And so I think that is a good system. But of course, once you leave the EU, from the perspective of the EU, it becomes redundant.
Well, are you going to miss making references, Emma?
Well, I have the power.
Have you made any?
But I haven't. I've only actually been asked whether I'd consider it, and it was rather half-heartedly, I have to say. There have only been two. And the CJU did hold that appointed persons could make references. There have only, in fact, been two made. One by David Kitchen in Emmanuel, which was the case where the CJU did hold that he had the power. I think there was an argument about whether or not he did.
You've
And the
got
other
8
one,
more months.
I've got 8 more months, and then there was also the IP translator case, which was a reference made by Jeffrey. It would have been wonderful to make a reference. I'm speaking from the other side, I would say, which goes slightly to what Richard was saying. I think the discipline of appearing before the CJU and the General Court is actually a really useful discipline that I will miss, because learning to speak and deal with those courts is a different skill, but I think quite a useful one. And I think that I will miss having that discipline from time to time in the more difficult cases that I've had. And perhaps we could learn from it for the length of submissions in the Court of Appeal and the Supreme Court here.
Something in that.
Question for Richard, actually. Are you the supreme champion referrer, or, having done 15 interviews? Are you aware of any other judge in the rest of Europe who's referred as many as you?
I'm not, but of course, don't forget that in most European jurisdictions, courts sit in panels of 3, and so it's less of an individual decision. Moreover, in many systems, discovering the identities of the judges is not always straightforward. So how you would make that comparison with many systems is a difficult question.
Judge Joachim Bornkamm, who was for many years the trademark man in the Bundesgerichtshof, said he reckoned he could refer every case he had and had to hold back. So uncertain was European trademark law.
That was a while ago, though.
Yes.
I think
You're not suggesting it's got any more certain since, are you?
I think the other point to make that in relation to appointed persons is that people who appeal to appointed persons are usually looking for certainty and finality without the expense of going off on references, and so tend not to ask for them. If they do want to go and appeal and go further, they tend to appeal to the High Court instead. And of course, in certain cases, if an appointed person thinks that something's very important, they're more likely to refer it to the High Court, and from there it may then end up on a reference, although I'm not aware that that's actually happened. I think in general, parties that come to the appointed persons want it as a final, unappealable decision.
Yeah, well, what Emma says is absolutely right, and I have personal experience of that. So the question on acquired distinctiveness came before me sitting as an appointed person in the Vibe case. And it seemed to me then, as I commented in my decision, it was plainly a referable question. But both parties urged me very, very strongly not to refer it. They really didn't want the extra time and expense that it would take. And so we didn't get an answer until the question came back before me in the Kit Kat case, when fortunately it was 2 well-resourced parties. And so I was in a position finally to get the reference and get the answer.
Let's move on to sort of less structural court structure stuff, but still a little bit of it. Procedure. Bad faith is getting a bit of a bigger place in trademark law, or maybe, than it had in time past. How is the best way of resolving it? The continental way would be just to look at the papers and say this guy's in bad faith, or at least most continental, but perhaps not in Scandinavia. We would do it by discovery and cross-examination. What's the best way of considering bad faith in trademark cases? Emma, would you like to start with that one?
Well, obviously, there's a big difference between the High Court and in the Trademark Registry. In the High Court, you will automatically, or almost automatically, get disclosure and cross-examination. It would be very rare, I think, for disclosure and cross-examination to be refused in a case of bad faith. In the UK IPO, there's a slightly different approach, and it could be regarded as a bit more like the continental approach. And I think this is largely down to the fact that it's a sequential filing of evidence. So you have, first of all, nowadays, a much stricter application of the rules of pleading bad faith in the UK IPO, but you then have sequential evidence. Now, it's not to say that you can never decide a case of bad faith on the papers. In some cases, it will be absolutely clear. And certainly, Geoffrey Hobbs in the club sale case, for example, set out the reasons why you don't necessarily have to have cross-examination. And obviously, Richard has also given decisions as the appointed person on this topic as well. My own view is that the way the case law has been developing on bad faith, in many cases, even in the registry, it will be necessary to have cross-examination. And I am aware that in a number of cases, cross-examination has taken place, albeit on a very limited basis. And looking at the decisions written by the hearing officers, it would seem that they found it useful. But there have been very few cases, as far as I'm aware, where parties have gone as far as to apply for disclosure in such cases. And it doesn't seem that the hearing officers have had any difficulty whatsoever in still coming to a conclusion and forming a view. So therefore, I think there is a case to be said. Each case is an individual case. I think Robin would probably agree with the sentiment. You usually know bad faith when you see it. And if you have sequential evidence where people have raised the case, it's been answered, and then there's reply evidence, often there won't be a need for there to be cross-examination as well. But Richard may well take a different view, as he's seen more of these cases.
Yeah, well, perhaps there's a sort of aligning with that. I mean, there is also the question of oral argument, the whole place of oral argument in the court. We all come from the common law. And perhaps, Ian, you could just say, but your colleagues mainly didn't. What was their reaction to the idea of advocates getting up and arguing cases and talking to them and asking them difficult questions and things like that?
Well, I think every one of them would say they find it most fun, most interesting, most stimulating to have advocates from the British Isles. The pleasure of hearing, and this is, I don't know how many of my colleagues have spoken, the pleasure of hearing a well-trained advocate with a clear set of points to make, making them briskly and making them honourably, that's to say, not going beyond what is legitimate in light of the documents and the facts of the case. That is one of the big contributions that the United Kingdom made, and Ireland, to the court from 73 onwards, and that's something that the judges say they're going to miss. With respect to how much advocacy is relevant, indeed there's very, very wide tradition. Those of you who've argued cases in Luxembourg will be able to identify the difference in judicial tradition. Some judges, most judges, if you do a count, would come from countries where judges listen in silence to the arguments made, where it's rude, really rude, to interrupt. It's like stubbing a cigarette out into a souffle. It's really, ugh. No responsible, decent person would do that. And where a question is, you said on page 7 that it's 9.3 million, but then on page 15 you seem to say it's 6 million. Can you explain? That's a question. But to say, Mr. Forrester, how can you argue that in light of our decision and da-da-da? Surely you must admit that kind of question you hear from the Irish and from the Brits, but usually, not usually from others. So to go to the particular question, we don't do discovery in my court. We do on the papers appeals against judgments, decisions of the Alicante Trademark Office. And we don't therefore sit at first instance, we're really at third instance when we look at an Alicante trademark. I've never had a bad faith case. There's the Sky Kick judgment, which from Luxembourg, which says I think, on the one hand, on the other hand. But the implication is, I would say, not having been involved, just looking at the words, that the court is saying it's only in the most exceptional circumstances that these arguments will prosper.
Yeah, the issue of bad faith is to some extent maybe linked with another question, which is the very long and huge specifications. Has that caused you any trouble in considering cases, any of you? Emma, huge specifications, it bothered you, or you simply say, well, never mind?
It's annoying because it can take you a very long time to work your way through them. I mean, obviously, it's less of an issue on appeal, but one of the points quite often is that the hearing officer has lumped together inappropriately chunks of specification when making his assessment, and therefore should have broken it down further. And it can take an awful long time to go through it. But that's the nature of the beast. You sit down and you work your way through it. And as counsel, obviously, in non-use cases in particular, you get used to working through long specifications. It has to be done. It's by virtue of the length.
Richard, have you got views on long specs?
Well, I've got to be a bit careful because the Skykick case is coming back to me. However,
okay, well then,
but what I can say is that I drew attention in my judgment, making the reference in that case to the length of the specifications of the Sky trademarks in that case, and the way in which they got longer and longer and longer over time. And it was partly a function of increasing coverage in terms of classes, but also it was to do with the impact of the IP translator decision. And you can understand from the perspective of trademark attorneys who are acting for applicants to register trademarks, they're trying to do the best for their clients.
Yeah.
And up until IP translator, it was possible to rely upon the presidential communication saying, well, class headings covers all. And so you had a period when people were filing applications which just the class headings. Then IP translator comes along and they realise that may not be good enough. So what do? Answer, as witnessed in that case, they keep all the class headings and then they put in every imaginable good within the class headings as well. And if the question 2 had been answered by the court in a different way, that could, I would freely concede, have compounded the problem, because you will recall that question 2 was about whether terms such as computer software were acceptable. And the court said that question didn't arise, having regard to the answer to question 1. But let's imagine what the scenario would have been if the court had said, no, that's not acceptable because it's too broad and too indefinite. Now, one possible response to that on the part of attorneys acting on behalf of applicants would be to say, well, in that case, we've got to list every variety of computer software. And so you could lead quite quickly to a situation in which specifications of goods would become even longer. So rather than being 10,000 words, they'd be 20,000 words. And to which one, at some point, has to say, well, is this really a good idea? Now, that really comes back to the debate about breadth of specification, as to which I can't say any more. But it does seem to me that there is a problem.
Yeah. Well, I think we've had enough with wide specifications. Why didn't they happen earlier? I have no idea. Why hasn't this always been a problem? Even more of a problem, perhaps, under the old Act, when it was either in the specification or not. Does it happen in America? I don't know. Does anybody in the audience know the answer to that question? Why is it a European problem and only European?
Partly in America, it's because you've got to declare that you're using the mark.
Yeah.
And evidence it in due course.
and then continue to fill in forms during the
Yeah.
time of your registration as well. It's not a sort of one-stop
Yeah, well,
obligation.
that was a great blunder when they did the European legislation. We should have had the same. It was trademark agents. They said it would be too difficult. I don't know why they bothered to get paid for doing it in the first place. And anyway, it's not difficult.
Well, you say that, but there are large numbers of non-use cases in the jurisdictions of the UK, never mind what happens in the European jurisdictions. And time and again, you see poor evidence of use being filed by trademark
This is an ancient
proprietors.
tradition of trademark agents never to put in proper evidence of use.
Yes, but then you speak to the attorneys and you ask why not. And every attorney I've asked that question say it's because the clients don't supply the evidence to us. And then you start asking the clients. And the clients give two answers in my experience. One, they say it's too much time, effort and money for us to dig it out. And then you say, well, but if this trademark's really worth it to you, why would you not spend the time, effort and money? And then the answer comes back, oh, actually, we don't keep the records anyway.
Yeah. Or actually, in my experience, it's usually the turnover of the marketing department is always so rapid that the relevant records of actually what has been really used has disappeared. So there's no one on the staff who can tell you.
Lack of institutional memory.
Yes. Precisely.
Have any of you written judgments which you want to make unappealable?
Surely we all have.
Deliberately so that you've written them in such a way that somehow or other there's no room for an appeal.
Are you looking at me?
You can start, yeah.
All right. Well, my situation will be different from that of my two learned colleagues. A member of the court in Luxembourg has référendaire. We draft in French. We deliberate in French. We send note en délibéré in French. So when you're speaking to your Anglophone colleague and you wish to say to him, how could you be so stupid as to suggest that ta-ta-ta-ta-ta, you have to say, je remercie Monsieur le juge Smith pour son analyse percutante et utile, mais je tiens quand même à se faire savoir que ta-ta-ta-ta-ta. So there's a paragraph of mush, and then you get into I disagree with you. So the référendaires are cautious animals, and they want their judge to look good. They don't want to be reversed. So if you have, and this leads into the question of prolixity, if you have 5 pleas in law, and each plea in law has 3 branches, subdivisions, then you need 15 rebuttals of these various arguments, so it is said, or so it is feared. Therefore, there is a tendency, of which I was guilty, because it was the normal practice of the court, to address every single argument, even the weak and hopeless ones, as well as the key arguments. So, in a sense, in every case, my contribution to the collective judgment, we sit in 3s or 5s or 15s. There's a juge rapporteur and 2 or 4 or 14 juge assesseurs who contribute and who sign. If there's disagreement, you try to compromise. If there's still disagreement, you vote. Now, that sort of human, linguistic, institutional environment, coupled with a very strong reluctance to be reversed on appeal, I think more acute than the robust personalities on my two sides, that makes each judgment something that's put together with a view to surviving a pourvoi, an appeal. And I remember that the first time I was appealed, indeed, was a trademark case where we went that way, and I was a little nervous, and there was a very short judgment saying we had been correct. So that is sort of an answer to your question. Every judgment that emerges from the General Court is drafted in a manner to survive appeal, and maybe it might be suggested that the General Court could focus more on the important points and give less weight, less space to the less important points in drafting its judgments, because that according of space to weak arguments tends to make for length.
Richard, did you ever write judgments with a view to making one appealable?
Well, of course, it depends what you mean. Any judge in any judicial system at any level below final appeal level will try to write decisions that will survive appeal. After all, what's the point of doing otherwise? However, the question is whether a judge would, as it were, distort the judgment writing process with a view to artificially trying to render a judgment appeal proof. And I don't believe judges would do that or do that. And it's liable to prove counterproductive if one were to try. The best way to survive an appeal is to be right for the right reasons.
Well, appointed persons can't be appealed. So it's not
Nobody's
really,
ever tried to judicial review.
I think there have been, for recollection, I think there have been about 2 or 3 applications, but they've never got beyond the application phase. That's my understanding. But I think certainly because I'm very aware that people have come to the appointed person because they want a decision, and we also have a significant number of litigants in person. I'm very conscious that when I am writing out, although I try to prioritise the important points and the less important points, I think it's very important to explain to people exactly why their appeal is not being allowed or is being allowed. And so I think that's really the focus when you're writing as an appointed person. And obviously you're not having to do it collectively, so you're sitting in your room and just getting on with it. But that's what I try to do. And I'm very conscious of the fact that you can't be appealed. You are the last point of call, and therefore you do need to address all the points that have been raised before you, even if some of them you address quite shortly.
Could I add just a thought? I've just finished an article which addresses the question which I assert to be a problem, that often my court drafts in what I call a winner-takes-all manner. In other words, we may give the impression that the case that we're rejecting was absolutely hopeless, whereas actually there was merit in it and it was rather difficult. And I think that far from weakening the authority of a judgment, recognising the arguments being rejected and their interest, even if they're not valid, I think that strengthens the prospects of a judgment on appeal rather than the reverse. But there is a little bit of that tendency in our habit.
Yeah, they're maybe not following what is a very good, strong common law rule. The most important guy in court is the guy who's going to lose.
Yes,
Yeah. I want to know why.
that's what Robert McGarry used to say,
But it goes back beyond that.
I imagine.
My own attitude about being appealed was, I didn't mind the appeal, but if I got reversed, I had 2 reactions really. One was, Lord forgive them for they know not what they do. Another was, damn it, I should have seen that. I think there were more, well, I was reversed, of the former kind than the latter. A more general question somebody asked is trademark law just too complicated? And how does it compare with other areas of law? So you all do, I mean, competition law and state aids and so on, terrorism cases. Richard may have done a family court law case, right? Yet I don't know.
Yes, I have.
What do you reckon? Trademark law got out of hand?
Well, in terms of its sheer complexity, it undoubtedly has become more complex. But I think it's an illusion to suppose that trademark law ever was or ever could be entirely straightforward. Trademark law, as Robin well knows, and most of you in the room I'm sure appreciate, is a slightly paradoxical animal because at first blush it looks quite straightforward. I mean, most people think they know what a trademark is. You know, the idea that you shouldn't be able to register a sign unless it's either inherently distinctive or has acquired distinctiveness seems like a perfectly rational proposition. The idea that you should be able to stop other people using signs which are confusingly similar also has a clear intuitive appeal. It all seems quite straightforward. But then as you get more into the subject, you discover that actually it's not simple. After all, what is a trademark? I mean, that's a question that trademark lawyers have been asking for more than a century, and we still haven't answered it. That's not a new question. And true it is that some of the legislation that we are faced with is not straightforward, but again, there's nothing new in that. I mean, most of you in the room are probably too young to remember Section 41B of the Trademarks Act 1938, the one that was famously described by Lord Justice Mackinnon as being as felicitous obscurity. It ran to something, what was it, 128 words? Or no, it's 144 words, I think it was. Incredibly long and hard to parse, let alone understand what on earth it was getting at. So it's always been the case that trademark law was more complicated than it appears, and one was faced with difficult legislation and often difficult case law. There's nothing new about that. And the ways in which it has become more complicated over time, I think, is to some extent inevitable. So it's been complicated by new technologies, new business models. Well, there's nothing you can do about that. That's just the way of the world. It's been complicated by the tendency of legislators to grant broader and deeper rights. But again, that's not a phenomenon unique to trademark law. We see that phenomenon in other areas of intellectual property law, and indeed outside intellectual property law. It's been complicated by globalization. Again, that's not a phenomenon unique to trademark law. So undoubtedly, it has got a lot more complicated, but I think it's become complicated for very understandable reasons. It would be wonderful if we could make it more simple, but making it simple is easier said than done.
Yeah. You started doing trademarks as quite a new boy when you became a judge, I suppose.
Yes, I found my first trademark cases rather nervous-making, and I was greatly helped by the fact that what we sit on is an appeal against a decision by a board of appeal in Alicante. So we don't have to we may get into the facts, but the principles in dispute are laid out for us in a way which which certainly helps understanding. I do know that the court's more expert members in the field of trademarks worry about consistency, and I have here a string of carefully balanced decisions which a kind colleague gave me, where the choices are tricky. But it's my impression, contrary to what we just heard, that trademark sophistication in London is more advanced than at the moment it is in Luxembourg. Whether that's good or bad, I leave to others.
Just another little follow-up here. For reasons that are slightly baffling, you get 3 tiers of appeal, 4 instances altogether for trademarks. You wouldn't get that for a treason trial.
Yeah, but don't forget that's the rules just been changed on that. So the Court of Justice has brought in new rules of procedure with regard to appeals from the General Court in trademark cases, which effectively amount to a permission to appeal requirement.
Yeah, it's still 4, but 4 was still potentially 4 though.
Yeah, but I mean, the indications are that they're going to take fewer or appeals from the General Court coming up from Alicante.
Yeah, I'm sure they've
Well, looking at it from another point of view, there's probably some competition lawyers in the audience, and that was my specialty before
That's
I
before
went,
he went straight.
before I got legitimate. So in competition, there's a structure which may involve an accusation, an investigation on the spot, a kind of, well, a hearing, which isn't a trial, but it's a rehearing of arguments made, and then there is a decision condemning behaviour and a public announcement. So it's not criminal, but it's tending towards the accusatory and is called often quasi-criminal. Now, the treaty gives the court the 2 heads of jurisdiction. One is to review on the basis of judicial review standards, actions of the European institutions. And in very rare circumstances where penalties are imposed, we have full jurisdiction over the penalties. That's the Treaty of Rome as amended and followed up. The Menerini judgment of the Court of Human Rights says that, at least in competition cases, we're obliged to do a full review of fact and law, a review in principle complete of fact and of law. Now, the court is constantly trying to balance its clear function under the treaty as amended of review of legality and its extra duty following Menerini and other cases from Strasbourg to do a review of fact and law. Now, when we look at an Alicante decision, we have the great benefit of having 2 instances below, and that clears the ground. Whereas if we have a competition case, it comes as a great slab of raw meat, a half carcass, still quivering and warm. Whereas if it's an appeal from Alicante, it's a nice little brochette with 3 sausages and 2 slices of chicken. Dead easy to approach and dead easy to digest. But the poor judge and his referendaire, or her referendaire, faced with the slab of ox, doesn't quite know where to look, and therefore is tempted, but this is not for today, to look for procedural imperfections which make it unnecessary to go too far into the entrails, shall we say.
And the comparison with competition cases is a very good one. So even under the purely domestic system, you have an investigation by the CMA, a decision by the CMA, and then that goes on appeal to the CAT, and then from CAT you go to the Court of Appeal, witness yesterday's decision in the Flynn Farmer case on excessive pricing, which will be of interest to many, and then it's to the Supreme Court, so same number of instances.
What do they do in Flynn Farmer?
I'm still trying to work it out, it's complicated.
Right, okay. If you're still trying to work it out, nobody else can get there at all.
Well, that's because I'm still reading it, and there's 2 long judgments.
Yeah. You think there's something to be said for giving judges fountain pens and 20 sheets of paper, and that's it?
then you have to limit the number of points being taken by the litigants.
Yes.
And one of the reasons why judgments are so long these days, as I've often pointed out, is the number of points being taken. I mean, in a patent case, I could easily be asked to decide 20 different issues.
Yeah, there was one we had in the Court of Appeal. There were 46 points taken by the defendant, and he lost at first instance because the judge had lost interest. He was right on point 34, something like that, and wrong on all the others.
And-
He got beaten up in costs, which you haven't got the power to do in the general court.
Well, we award costs, but the costs are by the standards of this city modest in the extreme.
Hardly buy you a lunch in Luxembourg.
Oh no, I don't think so.
In that case, when we did it, it was a patent case. Although the appellant won, he got no costs. I forget what we did with the cost below. Left it where it was, I think, or maybe even pay some of them.
I think that there's, let me add one more comment to what you two have been saying. There is a, I won't say vicious, but unfortunate circle here. And I see it particularly in competition cases, but it's maybe also creeps into other areas. The institution takes a decision and it's appealed, and on a little point number 34, the institution is found not to have consulted as to whether that report was made available to the party, and the institution is told your decision falls. Jeez, that's really irritating. Next time, we're going to be very thorough. And so next time, the decision is 250 pages long. And so the appeal is 150 pages long with maybe 500 pages of annex. And so the more voluminous the decisions of the commission are, the more voluminous the judgments are, and the more voluminous the judgment is, the more difficult it is to find the essence of what it is that has been decided. And that's a pity.
Yeah, it is. Procedure and settlement. How much experience have any of you got of mediation sort of being encouraged and working by the court? Do you do that at all in the general court?
Yes, I've done, I've suggested mediation in 3 cases, and we have done mediation in 2, each of them involving fonction publique, civil service cases. And in the 2 that we did, it worked and the matter was settled in one case, and in the other case it didn't, and the matter went on to judgment.
Richard, have you pushed people to mediate?
Not generally. I mean, when I was sitting at in the High Court, I frequently raised the matter, but often it was too late by the time it got to me for mediation to be feasible. I would certainly encourage people to mediate. It's remarkable what a good mediator can do. But the ability of the courts to influence it is not that great, unfortunately.
Emma?
I haven't. I mean, the cases in front of the appointed person, again, it's often too late, but there's a significant, a not insignificant number of people will write and say, we are now talking, will you not fix an appeal, or can you delay an appeal? And I will always encourage that and ask them to keep going, but keep me informed as to what's going on with the appeal. But speaking for myself as counsel, I think trademark cases in particular are very good subject matter for mediation, really, because with all due respect to the judges, an injunction or the kind of relief that can be granted after a trial. It's kind of binary and it's a blunt instrument, and often when you're talking about trademarks, there may be just a paper conflict. The reality is there isn't a conflict in the business world, and if they could actually sit down and talk about it and mediate, they can often accommodate so that everyone leaves thinking that they've got something. And so I do think trademark work particularly, mediation is of great benefit, but sadly I think by the time it gets to appeal and appoint a person or to trial in Chancery, it's just too late. But for me, I think trademark cases are particularly suited to a good mediation.
And could I add that you and I may be the only people old enough in the room to remember, but in the 70s there were a number of competition cases which were necessitated, if that's the word, by the reaching of settlements in big trademark disputes, Purcell, Salma Penny and so on.
Yeah, I was in Penny.
Ah.
When it's settled, I mean, the competition law is and its interference with the settlement of IP disputes is a hot topic at the moment. In patents.
Let's not go to pay for delay, please. We'll be here all evening.
I'm teaching it on Monday. Now, audience, you've been very quiet. How about being noisy for a bit? Asking a few questions. Yeah.
I acted for Delors in L'Oreal and Delors, and I've asked this question of Robin before as to when he said he was forced to condemn a perfectly lawful product, whether he would see this fit for divergence. And I wonder whether a model in Hague 1 and Hague 2 could be adopted. And as a statement, I just wonder whether or not we don't need to look at what the UK will do, because I agree, I don't think the UK will do anything. But I think the EU will diverge, necessarily with 27 states making references and the UK carrying on its merry way.
Can I answer that question in a different way? Because the tail end of it raises an interesting point, which is that there is a strong possibility, given the institutional design of the 2018 Act, to which I referred earlier, that what will happen, certainly in the medium term, if not the short term, is that the UK stays exactly where it is now and does not diverge, but the EU 27 do diverge. Because what we will have is the case law of the Court of Justice frozen at a moment in time. And we will continue to obey that case law because it's part of our own domestic case law, but the Court of Justice will carry on developing the EU's case law, and slowly over time they will diverge.
We end up like Jamaica.
That's one way of looking at it.
Anybody else? Yeah.
I should just take that point a little bit further. But if say, next year there are useful decisions coming out of the Court of Justice on particular points which are relevant to a UK case, to what extent does the panel think that they might still look at the outcome of a Court of Justice case, which may answer a particular question which may be relevant to it?
Well, it's going to be persuasive authority. And this is going to be a huge topic.
It's just the same as the judgment of a German court.
Yeah. So if you've got a judgment of the Court of Justice, which is A, interpreting the same legislation, and B, as is likely to be the case in the trademark field, is laid on top of previous jurisprudence, then it's got to have persuasive force. Now, you're not bound by it. You might still say, well, I'm not going to go there, but it's bound to have some persuasive force.
Yeah, right.
Robin, just following your point, it's not quite the same as a German judgment now, because now there's a sort of general wish to try and harmonise, whereas I'm not sure that same desire necessarily is going to be there later.
True.
I think, going back to what I said at the very beginning, this question, I think, will come up it might come up in a trademark case, but I sort of think it might come up in something more technical and more close to public perception or public sensitivity. So it might be animal feed, it might be safe toys, it might be environmental protection, it might be protection of migrating birds, where there is a policy that can be perceived by consumers, by NGOs, by political parties, by activists. There's two policies, and the English judge is under pressure to adopt one of them and reject the other. And then the English judge is told, well, there's this highly relevant judgment just last week from Luxembourg. Now, what weight to attach to that subject, to that phenomenon? You would expect that a judge would probably, because they're conservative animals, be likely to wish to maintain consistency. But that's an enormously sensitive political topic. Now, you heard also at the beginning of the legislative steps which have been taken up till now. Now, it is envisaged that government ministers can sort of grant get out of jail free cards or rewrite the rules cards in certain circumstances. How's that going to work? How's that going to be digested? These seem to me enormously sensitive questions. It might come up in a trademark context, but it might come up in many other contexts.
Yeah, it's liable to hit the Supreme Court in another context first, that's for sure.
I only suggest I ask this one, Mr. Lamar. If you could devise a faster track than we have now, what would you do? Just give the 2 marks to the judge and say yes or no?
Well, it depends what aspect of trademark law you're talking about, because don't forget, an awful percentage-wise, the vast bulk of trademark disputes in the United Kingdom are handled by UK IPO, and that is, these days, pretty fast, and it's always been cheap. And when you go to the appointed person, that's again pretty fast and cheap. Where it gets more expensive is for infringement disputes, but of course there we've got these days the availability of IPEC, including, in an appropriate case, the small claims track. And that's pretty fast and pretty cheap.
When I was sitting in the Court of Appeal and I was doing L'Oreal, remember there was another aspect of L'Oreal, which was the so-called historic, and I had them all lined up in my room. Plaintiffs, defendants, plaintiffs, defendants, plaintiffs, defendants. John Mummery came into my room, he looked at them and said, no. They were all found to infringe, but his immediate instinct was no, just like that. And that's, of course, what actually happens quite often. If you take a registered design case, you look at one, you look at the other, yes or no. And Michael Feisch told me that was exactly what he did when he was a pupil to Russell Clark. He went into Russell Clark, and Russell Clark showed him all these pairs of things in his room, and you say yes or no. So it's a bit odd, really. We sometimes over-intellectualise some of this stuff.
Works in Luxembourg.
Yeah. Sometimes you ask your clerk.
Yeah, sure.
Well, now then. We can have another question, or we can have drinks. Those in favour of another question? All right, drinks. Thank you all very much, and thank you.